Next case is Meritage Homes versus Lake Roberts Landing Homeowners.
May it please the court. My name is Mike Furbish. I represent Meritage Homes of Florida, the appellant in this case. Since there's a cross appeal, I guess I'd like to reserve 7 minutes for rebuttal. And I'll try to devote most of my time now to the issues we raised in the initial brief and to an issue that kind of came up last week, which I'll talk about in a second.
Yellow light will come on when you're into your rebuttal time.
Okay, thank you. The first issue we raised in our initial brief regards constitutional conflict. We are arguing that the trial court's final judgment in this case created a conflict between Florida Statutes Chapter 720 and the Winter Garden Gated Communities Code.
Let's start with the issue of as to whether waiver actually occurred, because if waiver didn't occur properly, we never get to the issue of whether there's a conflict or an unconstitutionality, correct?
Yes, Your Honor. If the trial court's finding regarding waiver is incorrect, then
let's
I would
talk
agree.
about subsection F of 720.303, which is the section that deals with how reserves can be waived or reduced.
All right.
What voting rights, if any, does the developer have before the turnover?
The same voting rights as any other member, except under this declaration, they've got 9 votes to every 1 vote of the membership, because prior to turnover, the developer is a Class B member, which has some specific ramifications in the Declaration of Covenants for this community. The statute itself, and I think you're referring to the language towards the end of the statute that says after turnover, the developer, and I know that's an argument that the appellant or the appellee has made in their brief, but the more logical interpretation of that part of the statute is simply a recognition that the developer will continue to have the right to vote to waive reserves.
Before the turnover, would the developer be able to vote its voting interest to waive or reduce the funding of reserves?
Yes, Your Honor.
So,
because the right to vote to waive reserves belongs to the membership.
okay.
And prior to turnover, the developer is a member.
In another context, the law that says we don't interpret a statute such that a section has no meaning at all.
That's right, and there's other portions of the statute that actually refer to a non-developer member's right to vote. And that language is not in chapter 723.
If the developer has the right to vote its voting interest to waive or reduce the funding of reserves before the turnover,
yes.
What's the purpose of this section, or why would it not be in effect or of no use? Because if they've got it before and they've got it after, why do you have a section of the statute that says they have it after?
It's a recognition of the developer's continued right to vote following turnover of the community to the non-developer members. And I'd point out that at turnover, the developer transitions from Class B membership, which entitles the developer to 9 votes for every 1 vote of every other member, to Class A membership.
Section H, which is the statute, which is
Yes.
what we're discussing, says prior to turnover of control of an association by a developer to parcel owners, the developer-controlled association shall not vote to use reserves for purposes other than those for which they were intended, without the approval of a majority of all non-developer voting interests, voting in person or by limited proxy, blah, 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 blah. So what that tells me is that the developer shall not vote to use reserves for any other purpose, which indicates that they don't have the authority without a majority consent of the homeowners to waive the reserves.
Well, no, that simply means the developer wouldn't have the right without the majority vote of the homeowners to change how the reserves are being used. What that section refers to is the use of reserves. So once it's been established, a reserve is typically set aside, for example, to pay to fix the roads in 20 years. And what that provision of the statute says is developer can't decide unilaterally to use that money for something else. And I think that makes a lot of sense, but I would argue that that section of the statute actually supports our argument, because that section of the statute is very specific in saying that the non-developer members would have the right to vote versus the developer. In the other section, 720.303, all of the membership is entitled to vote. And even under the declaration, members includes every owner, including the developer. Well, the developer owns a lot. So even under the declaration, the developer would have the right to vote. So I would respectfully disagree that the after turnover language in the statute has the implication, Your Honor, that you're suggesting that it does. I believe that it actually would support our argument.
Does the reference in section F to a meeting at which a quorum is present refer to a membership meeting?
It refers to a meeting at which a quorum of the membership is present.
Okay.
And that's different than a membership meeting. There's other portions of the
So it could
statute.
be any kind, if the developers own a majority of the votes,
Yes.
they could just sit down in the office one day and decide to waive the reserves. They wouldn't have to do it at a board meeting, they wouldn't have to do it at a membership meeting, they could do it privately because they're meeting and they're the majority. A quorum is
No,
present.
because that's not true, because the protection that would be afforded to the homeowners in that instance is they're entitled to notice of that meeting. And it's undisputed in this record that all of the homeowners, and there were only 7 when this vote to waive occurred. There was no mathematical way that those 7 homeowners, had they actually shown up at the meeting, which none of them did, there's no mathematical way that those 7 homeowners could have outvoted the developer in the decision to waive reserves. So that could not have happened.
Were they notified that an issue for consideration was the waiver of the reserve?
They were notified that the budget was going to be considered, and there's testimony in the record that the budget, which includes the reserves, or doesn't include the reserves in this instance, is the reserves are part of the budgeting process. So I don't know that the notice was specific about saying we're going to talk about waiving reserves.
Vote at board meetings?
They do. I mean, they would have had a right to vote. All the membership would have a right to vote. I'd like to, if there's no more questions, there's one thing I think I really need to point out here, and it came up last week. I don't know if you saw that I filed a notice of supplemental authority in this case. I did that because I felt like I had to. I felt like the duty of candor kind of required me to, even though I got to be honest with you, the cases I filed were not especially helpful to our position in the case. So as it turns out, there's a different type of conflict that I think if you agree with us that the ordinance conflicts with the statute and the statute should control, there's another type of conflict that I at least think you should be aware of. In the cases that I filed last week, the issue wasn't a conflict between a statute and some municipal ordinance. The issue in those cases was a conflict between the statute and the declaration. And in those cases, so in our cases, or in our view, in the cases we rely on for the point we made in appeal, the statute should always trump the ordinance if there's a conflict. But what these cases say is that the declaration trumps the statute if there is a conflict. And the reason I say that that's not good for us is because the declaration in this case was recorded in May of 2007. And the statute that permits the right to waive reserves was enacted in July of 2007. So the statutory right to waive reserves did not exist at the time this declaration was recorded. And I would have to concede that it's not incorporated anywhere in the declaration. And what these cases say is that if the declaration provides for automatic amendment in the event of legislative action, you would continue to be subject to whatever rights are included in the statute by way of a post-recording amendment of the declaration. But I looked through our entire declaration, and it doesn't say that. So there's another potential constitutional problem in this case, because I think if these cases control, and they certainly appear to be the state of law in Florida, the most recent case was 2015, I think that the declaration would control, and that would pretty much,
Calls for reserves.
And that would pretty much do away with our right to waive. And I struggled to bring that to your attention, but I felt like I had to. But here's why I think you don't have to apply those cases. Because here I am, for the first time, telling you this. That never came up. Never came up any time during the trial. And in fact, the issue of conflict between the statute and the ordinance, that only came up at trial. That never came up before. Neither party talked about it, neither party alleged it, neither party brought it up. It was something the trial judge really seized upon based on comments that were made by Mr. Howell during his opening statement, and she asked the parties to brief the issue of preemption. But this issue, the issue regarding the potential conflict between the declaration and the statute, that's never been raised until today. And I know that the appellee has made a tipsy coachman argument in the brief, and I guess that's if the trial judge is right for the wrong reason, then you have to affirm. But the way I understand that doctrine to work, and it's not something I have a lot of familiarity with, I'll concede, but the way I understand that to work is the wrong reason that, or the right reason, or whatever it is, the other thing that makes a judge right has to be in the record. And it's not an end run that you can use around your duty to bring an issue to the attention of the court. And so, although I guess I would have to concede that these cases that I found last week aren't helpful to us and probably do away with our conflict argument, I don't think you have to apply them because they were just never raised.
Let me commend you for your candor, sir. I will do that.
I wish my client felt the same way, Your Honor. I say that facetiously. The guy that I report to is actually an appellate attorney, and he was on board with doing this. So. That is a segue, however, to the other second issue that we raised on our brief, which is estoppel. It's the law in Florida that a party should be estopped from changing positions to the detriment of the other party. And based on the record in this case, that's exactly what the association did by raising this argument at trial that these Winter Garden reserves were unwaivable. And so I went back through the record to try to figure out when is the first time this issue about waiver under 720, when's the first time it got introduced into the case where one of the parties said, hey, we have the right to waive if we complied with 720-3036. And the first time it came in the case was in answers to interrogatories that were served by the association in April of 2013. And I'm going to quote it. It's in the record at 2366 to 85. And I'm going to quote it anyway because I think it's important for the purposes of evaluating this argument. What they said was, mind you, under oath, the reserve accounts were established pursuant to section 720.30236D, Florida statutes, and were required to be funded pursuant to section 720.3036F, Florida statutes, unless properly waived under section 720.3036F Florida statutes. As funding for the reserve accounts were not properly waived by the members of the association, Meritage was responsible for funding the same. That was the association's sworn interrogatory answers.
What was the question that led to that answer?
I believe the question was, we asked the basis of their contention that the waiver provision in the declaration in section 15, why they believe that that provision was not valid or shouldn't be enforced. I could get you the actual question, but that's my recollection as to what it was. But that's what they said. But then they said the same thing in a motion for summary judgment that was filed in June of 2013. And then they said the same thing after summary judgment was denied. They said the same thing in a motion for reconsideration that was filed in October of 2013, where it said a waiver of reserve funding may only be accomplished by a majority vote of the membership at a duly held membership meeting. And I think it's important to point out that the trial court's order on summary judgment wasn't one of these, one-liners that you see sometimes where summary judgment is denied. It was a very thorough 6-page order that went through all of the requirements of the waiver statute and specifically identified all of the issues that remained for trial. And yet, despite that, it wasn't until 4 months later, at or right before the trial, that the association said for the first time, and oh, by the way, it doesn't matter if you complied with the statute, because these reserves aren't waivable anyway, because they're mandatory under the city code. And that was a pretty important change in position in the case, Because all throughout discovery, what we thought we were litigating was, well, did you waive right? The question that we sort of started with
Did the
today.
complaint, though, did the initial complaint and the amended complaint reference the city code?
It did, and it said that the city code requirements are mandatory.
How are you not on notice by the initial complaint and the amended complaint if it references that the city code required or obligated the reserve account?
Because what we believed is they thought, as we did, that the city code was subject to the statute. And I realized that the city code is couched in mandatory terms, but if it's subject to the statute, you would still have the right to waive. So the fact that they track the language of the city code doesn't necessarily put us on notice that they don't believe the statute applies. And in fact, the complaint also makes numerous references to Chapter 720 throughout it. So it's not like the complaint never said, there's no allegation that these reserves are mandatory, and because they're mandatory, you can't waive them per the statute. That's not what it says. You have to read that into the complaint, and in fact, throughout the case, they were telling us the exact opposite.
Well, what could possibly be any other meaning other than the city code required and obligated Meritage to have the reserves? I mean, what is ambiguous about the words required and obligated?
I don't think that it is ambiguous, but what's not being said is that you're obligated to fund them unless they're properly waived. And remember, it was the association in those sworn interrogatory answers that first came to us and said, you can waive these, but only if you do this, only if you comply with the statute. And that's what they told us, and we spent months litigating over that issue. And the irony is, we actually prevailed on that issue at trial, but it became a non-event when the court found that, well, you can't waive them anyway.
The issue that you say was raised too late,
Yes, Your Honor?
did it just raise a legal issue as opposed to a factual issue? Was there discovery that you say you would have done that you couldn't have done? Or was it simply you now had a legal argument you had to prepare?
I mean, I think there is some additional discovery we probably could have done. I mean, maybe we could have deposed somebody at the city to find out what their take on it was, whether it was subject to the statute. But certainly, you know,
Well, that would only apply if we determined there was an ambiguity and you could get to parole evidence, right?
I would concede that point, Your
And so
Honor.
if
That's
the
correct.
argument is, here's the statute, here's the ordinance, is it unconstitutional? That's really just a legal argument, right?
Sure,
It's
but-
not so how do you show, normally you show prejudice by a late disclosure by saying, discovery's over, I could have done discovery. If the only argument is, here's a new legal argument, you certainly had enough time by trial to prepare for that, right?
Yeah, I would agree that we had time. I mean, the judge gave us an opportunity to brief the issue of conflict and preemption. So I don't deny that we had an opportunity to brief the legal issue in the case, but the prejudice is really twofold. There's a practical prejudice involved. We spent all of this time and effort and money to prove that we complied with the statute when we waived, and we prevailed on that issue, and it was all for naught. It was like a big waste of time. Had this been brought up earlier, and maybe there's a substantial prejudice as well, had this been brought up earlier, maybe our strategy at mediation changes. Maybe we decide we want to settle the case.
You're into your rebuttal, way into it, if you want to reserve the rest of your time.
I'll reserve.
Good morning, and may it please the court. My name is Patrick Howell, and I'm here on behalf of Lake Roberts Landing Homeowners Association. I will also jump right into the issue of 72303 and some of the language that's indicated in there. Meritage believes that it can be a board meeting where this vote can occur, and I believe that that goes against the exact language that we have in 72303, where it says that the membership of the association, upon a majority vote at a meeting at which a quorum is present, may provide for no reserves or less reserves. A meeting where the membership is voting under 720 and under the governing documents of Lake Roberts Landing is a membership meeting. It can't be a board meeting. This was, as pointed out by the panel, noticed as a board meeting. It was not noticed as a membership meeting. That's important, Your Honors, because under the governing documents of the association, the bylaws specifically, 15 days notice had to be provided to the owners so that they could attend and vote and discuss this possible waiver of reserves. 15 days notice was not provided, only 14 days notice was provided.
What do you say with regard to his argument that, well, if it's a membership meeting and for those lots, I guess, that aren't sold to homeowners, that the board has, I guess, for each lot 9 votes versus the 1, that even if we called it a membership meeting, they would have lost regardless?
Because I think it's a due process issue, Your Honor. You know, the idea is that these owners, these 7 owners that were mentioned by Meritage, they had the right to come to this meeting. They had the right to discuss this issue of waiver, which again was not put on any sort of notice for this meeting. They had no notice that there was going to be a discussion regarding waiver of reserves. And they had the right to debate that issue. That's what you do in a meeting like this. So even if the Meritage representatives went into that meeting, of course we do not know whether they went into this meeting with the idea that they were absolutely going to waive reserves, but they could have been convinced. They could have been convinced by these owners, you know, this isn't fair. This isn't what we signed up for. This is not what the city of Winter Garden requires. And those representatives working for Meritage that were appointed to the board could have been convinced and said, you know, that's not fair. You're absolutely right. Let's put these, let's keep these required reserves in place. So that due process was denied to those 7 homeowners, and that's what brings us here today.
Did the developer have the right to vote their votes at that point on this issue?
Well, I believe that based upon the language that we have in 720, I think Your Honor zeroed in on that earlier. And I think if you read everything together, which is what Meritage asks us to do, I don't believe that they did. I think that the language that was mentioned earlier, that's from subsection H, which says, prior to turnover or control of an association, the developer-controlled association shall not vote to use reserves for purposes other than those which they were intended. I think reading that back with the provision that is in F, that says, after turnover, the developer may vote its voting interest to waive or reduce the funding of reserves, leads to the conclusion that that the legislature did not want developers voting to waive reserves prior to turnover.
That argument seems to be inconsistent with the argument you just made a minute ago, which is one of the reasons for the notice is maybe the homeowners could have convinced them not to waive the reserves, but if they didn't have the right to vote on it, that argument doesn't make sense to me.
Well, it's certainly in the alternative, Your Honor, and I think that if there is a finding that the developer was entitled to vote its interest at that meeting, I think that at the least, that meeting should have been conducted correctly, and the notice of the meeting should have gone out correctly to the owners, and the notice that was required under the bylaws and under the membership provisions of 720 should have been complied with.
There was a notice, but you say it wasn't the right length of time, is that correct?
It wasn't provided with 15 days notice mailed. Right, it was provided with 14 days mailed notice.
Any homeowners show up for it?
No, Your Honor. And the other thing is that what the record shows is that the meeting was actually held in Orlando at their corporate offices. It was not held in Winter Garden near the HOA, which is where all of their other member meetings occurred.
It was noticed as a board meeting?
It was noticed as a board meeting, and that's uncontradicted. Virginia Musselwhite, who is the representative that testified on behalf of Meritage, both in affidavit format and then also at the trial, confirmed that it was a board meeting. If you look in the Meritage briefs, they do say that it was a board meeting / member meeting. It was not noticed that way at all. And so I think that the due process issue is, I think, very, very important. And again, it's also important that the agenda never mentioned that that was going to be discussed. I think that if waiver of reserves was something that was prominently displayed on any sort of an agenda, that the homeowners would have showed up.
Opposing counsel indicated that members would have been able to vote at a board meeting. Do you agree with that?
I don't. You know, representing HOAs and condos is all that I do and much of what my firm does. And there's a big difference both in the HOA Act and all governing documents as it relates to a board meeting and a member meeting. A board meeting is a meeting where the board makes decisions on behalf of the HOA. And the owners are entitled to attend that board meeting, and there's even provisions in the HOA Act that allow them to ask questions and participate. So they're allowed to, and it's sort of the HOA version of the Sunshine Law. They're allowed to come and listen. But they're not allowed to vote, and they're not allowed to really do anything except for ask questions. In fact, the board's not even required to answer questions during that. They can just listen to they're just required to listen to the questions that the owners may have. A member meeting is completely different, and there's all different sorts of examples in the HOA Act of what happens at a member meeting. The members vote for the board at a member meeting. That's where that election occurs. If there's going to be litigation, like the litigation that brought us before the lower court in this case, the association owners have to actually vote to approve that litigation if it's in an amount over $100,000. So the HOA Act has all sorts of instances where it shows that there is a big difference between a board meeting and a member meeting. As to the constitutionality issue, I do appreciate opposing counsel bringing up the issue of the cases that were discovered related to that issue. I think it is important that the declaration here was recorded prior to 720 and the new provisions regarding waiver coming online. I think for a lot of reasons, and I discussed those already, we really don't have to get to that point, but if your honors do believe that there is some sort of a right to waiver by a developer in that instance, I think it is significant that the declaration was recorded first before the 720 provisions were added in. And what the cases that were cited by Meritage indicate is that if the declaration comes first, a statute can't impair constitutionally that contract. So I do agree with that. But there's also lots of reasons that we don't need to get to that analysis. I think that the Winter Garden Ordinance complements 720 as opposed to conflicting with 720. There's a lot of similarities between the provisions. Both statutes require a very similar calculation of the reserves. And that calculation is basically the cost to replace the item divided by the remaining useful life. So we have a similarity there. The biggest similarity, I think, is that both statutes have the stated goal of protecting homeowners. It's a consumer protection device that's been inserted both in the ordinance and in Chapter 720. As everybody knows, reserves for an association, whether it's an HOA or a condominium, are a good planning tool. HOAs can take years to turn over from developer control, and often when they do, the roads and the drainage, especially if they're private roads that are the responsibility of the HOA, may be at the end of their useful life. And so if an HOA gets to turn over and those items are at the end of their useful life, then they face a very expensive prospect for repairing those roads or replacing those roads or drainage systems or any of those other items. So it would seem that both the ordinance and the statute were created to promote reserves, not the other way around. And I think that's significant because what Meritage would have you believe is that the waiver provision was somehow inserted in there to protect developers, and that's not the reason that the reserve requirements or the allowance for reserves was inserted. It's just the opposite. It was created to protect homeowners, and I think protect homeowners against developers.
Can we get to your cross appeal on the
Sure.
The amounts of, I guess, damages?
Yes.
the, you put on an expert, they put on an expert, the judge decided, listened to the testimony and picked which expert the judge believed. So why would that be an abuse of discretion?
Your Honor, I think if it was done that simply, it would not have been an abuse of discretion. And I think what the distinction is that we're not talking about calculations that different experts relied upon and came to based upon facts that were in evidence. I think the mistake came with the fact that the expert for Meritage relied upon a calculation that adjusted the damages by giving Meritage a pro rata credit, basically, for what Meritage would have paid had they funded the reserves. And
Why would that be wrong?
because the very first budget that Meritage produced in 2007 set aside $11,000 for reserves. And under the calculations, if you look at that budget, what they did was they showed it as being paid only by Meritage. And the rest of the assessments that were going to be paid were going to be a part of the rest of the budget for the association. So it was never contemplated from the very beginning that the homeowners were going to be paying these reserves. It was always going to be Meritage doing so. The other thing, Your Honor, is that under the governing documents and under Chapter 720, they are doing something that is called deficit funding. And what deficit funding does is there's a budget that's created, and then a assessment is also created for the homeowners that are living there, and as they start to move in and buy their homes. Many times that assessment is artificially low, or maybe it's a rounded amount so that it doesn't look like a really weird number for new homeowners that are coming in or thinking about buying homes in these communities. Right, that's it. So
Make up the difference, right?
right, so but basically what you do under deficit control, and it's always at the beginning, and then later they change it. But while they're selling homes, they deficit fund whatever the homeowners pitch in under their assessments, they pay, and then the developer will pick up whatever is left over, and they'll pay everything else. So there was never a point before the switch over to straight assessments where they were paying assessments. So what the expert did was he completely suspended reality and almost went back and said, well, if they were going to be funding these reserves, they would have then switched from deficit funding to the payment of straight reserves, you know, and they would have done it this way. So he just took too many steps that I think aren't realistic.
And what in your view becomes the remedy? Is it your position that we have to reinstate your expert's number even though the trial court didn't accept your number because he improperly accepted the other number, or is there some other remedy?
I would love that, but the other option for the panel would be also to just remand for the trial court to look at the materials and look at the numbers that were provided and the expert testimony that was provided and issue a damages award that would be consistent with your ruling. I think that either one of those would be fine in this circumstance. We do have a cross appeal, obviously, so unless there are other questions, I would probably reserve a little bit of time for that, if I can do that. Thank you.
Your Honors, I just want to make one more point before I address the cross appeal, and that's that the trial court's findings with respect to the developer's compliance with the waiver statute are all findings of fact that should be supported if there's competent substantial evidence that favors them, and I believe that there is ample evidence in the record to substantiate the trial court's findings in that regard, and in particular the declaration, Your Honor, which states that each owner, including declarant, shall be a member of the association and grants voting rights to all the members, including the developer, and the developer is the sole Class B member, was entitled to 9 votes for each lot in the property owned by declarant. So, Your Honor, the developer clearly had the right to vote at this meeting. And in terms of the length of time of the notice or the form of the notice, all of those are issues of fact that should be, that are up to the discretion of the trial court. Regarding the cross appeal, this issue about our experts' testimony being based on speculation, the biggest problem with that argument is that it was not preserved for appeal. The HOA stipulated to our experts' expertise in HOA accounting. So they stipulated that he was an expert. While he testified, there was not one objection made by the association, and there was no motion to strike ever made contemporaneously to any of his testimony that was offered at the trial. We believe that this is governed by the Roos and Griffin case that we cited on page 21 of our answer brief, where it was basically the exact same situation, and the court found that in that instance, where there's been no contemporaneous objection made, that argument is waived for appeal. I know that in their reply brief, the association has cited a couple of cases to try to get around that, but in both of the cases that they cited, the objection was made either before the trial, in some sort of a pretrial motion, or during the trial, and that's not what happened here. The first objection that was ever made to our expert's testimony was raised in the written closing that was filed probably a month after the trial. So the trial court was deprived of any opportunity to rule, and we were deprived of any opportunity to react. And so for that reason, that's not an issue that the court needs to address in this appeal. Regarding the issue of deficit funding, that's a non-starter as well. What the association is trying to do is use the obligation to fund deficits in the operating budget as a way to bootstrap an obligation to pay for all of the members' share of these reserves had they been set aside at the proper time. And I see that I'm almost out of time. I would point the court to section...
You're out of time.
Thank you, Your Honor.
Your Honors, with regard to that argument about the required objection, the parties, because we were running tight on time, I'm glad that wasn't me, we're running out of time with regard to this trial as a one-day trial, so we were packing a lot in. And so the stipulation was that we would do our closing via paper briefs. And so the objection to the testimony of Meritage's expert was included within that. So I think for purposes of looking at the trial, it was just as if a closing statement or closing arguments were made at trial. It's just that it was done via paper, via briefs.
Does that adequately object to the admission of certain testimony? Because your argument, as I understand, your objection would have been there's no foundation for this part of the report, right? Because there's no evidence that they would have done it this way. If that objection had been made during the course of the trial, arguably it could have been dealt with by the other side by, for example, putting on a witness to then lay the foundation, right? They lost that opportunity because there was no contemporary objection.
Well, I would have to go back and look at the actual testimony, Your Honor, but I don't know if the testimony of Meritage's expert was explained that way. I think the numbers were explained.
Is it the methodology that you're talking about, or was it an evidentiary issue?
It was the methodology that was used based upon the evidence. Yeah.
The methodology complaint, because you said there wasn't facts in the record to support him using that methodology.
That's
right?
Exactly right, Your Honor.
If you had made that objection at the time, the other side would have had an opportunity to provide that foundation, right?
Well, the way that it came up, as I remember it, was when I cross-examined the witness and asked about the methodology and where it came from, and I asked a lot of questions, you know.
But by then the report was in, right?
By then, the report was in. Your
Okay,
Honor.
so when they moved to put the report into evidence, would have been the point at which you could say, I object to it going into evidence, there's not a foundation, there's no evidence to establish this fact, and if the trial judge had agreed with you, the other side could have said, fine, Your Honor, we'll lay the foundation and now put a witness on to lay the foundation. They lost that opportunity because you didn't file a contemporaneous objection, right?
Well, I believe that the objection that was contained within the closing was enough, and I believe that the
How does that allow them to go back and lay the foundation, as it would if it had been made contemporaneous?
Because on cross-examination of the witness, I asked a lot of questions about that methodology, and I criticized that methodology.
Already in. You let it in. It was for the judge to consider. If there was no foundation for it, then it doesn't come in and the judge can't consider it. Once it's in evidence, the judge has a right to consider it, doesn't he?
Well, I believe the judge has a right to consider anything, but I believe that...
Well, he wouldn't be able to consider it if the report had not gone into evidence.
That's-
If he can't consider anything,
I will-
it's not in evidence.
I will concede that, Your Honor, correct. I have 1 minute left, but if there's any other questions, thank you very much.
Thank you.
Enjoy your day.